Now, without much further ado, I'll hand time over to Ajinder, who will tell us more about how crypto is treated legally in Singapore. Over to you, Ajinder.
Thanks, Florence. Thank you all for joining us this afternoon. Now, crypto, I think you've been hearing a lot about crypto in the last year or two, especially on the failings and the crashes. FTX has been in the news recently as well, not for good reasons. But apart from that, so many have failed in the last 1 or 2 years. But despite that, we all know that crypto is here to stay. The only issue is the law is struggling with crypto in terms of how to define it, how to regulate it, and how do you sometimes even monitor and recover assets if they've been taken illegally, for example. And in Singapore has come up recently with a new regulatory framework for Singapore-issued currency stablecoins. Initially, Singapore was trying to take a much lighter touch on crypto in terms of regulation, but given the issues that have emerged from the crypto world, it has started to increase some of its regulatory framework for crypto matters, and this is one of them. Basically, it regulates how you can how cryptocurrencies, Singapore's issued currency stable coins are to be pegged against the Singapore dollar, and this is just to kind of give retail investors, especially, some comfort and some protection in case there's a failure. But the problem with crypto is this: what is it? Is it money? Is it money? What value does it have? Is it just like the dollars in your wallet? And can you wind up a company on the basis of debts denominated in cryptocurrency? So there are many legal issues that people are grappling with, especially the courts. And the courts here, especially in the last 1 or 2 years, have had a slew of cases come before it. And we are going to try and unpack some of those cases for you today. But for purposes of today's session, what we look at is the evolution of cryptocurrency, how it's evolved to these complicated issues that it has today. And then this very strange wording here I put: can interlocutory injunctions be granted over cryptocurrency? I will unpack that for you. This is basically has to do with claims, meaning someone has unfairly taken or stolen your crypto. What can you do to recover it? And linked to this issue is, what is crypto? Is it property? And is it money? And how do you treat it in insolvency? Can you wind up a company for crypto debts? These are the issues that we're going to explore this afternoon. And let's go to the first one: evolution of cryptocurrency. Well, crypto originally sprang from a search for basically a system, internet system based on cryptographic proof that instead of trust, that any two people could transact with each other anywhere in the world without the need for a trusted third party. What does that mean? Basically, it's a way to allow two people to transact with each other without having to go through, for example, a bank or any other financial institution. They can have an electronic payment system in place for them to do their transactions in a manner that is trustworthy without needing to turn to the banking system. And this is enabled because your Bitcoin is recorded in a network of computers. The records are publicly available across the internet, and they provide a digital record of every transaction that has taken place. And these records are accurate, verifiable, and you can even they have an audit trail. So that's how this system developed. And basically, the system works on two keys. One is called the public, and the other one is the private key. The public key is freely available; anyone can access it. But the private key is held by the holder, and this is the key that helps you to, for example, do the transaction. To do a transaction, you need both the public and the private key before you can transfer a crypto asset to someone else. And once you do the transfer, the manner in which it has been transferred, and roughly put it in layman's terms to whom it has been transferred, can be seen from the blockchain. But crypto then started developing very significantly differently from what it was originally set up for. Originally, it was just a store of value. But what happened then? People started coming up with virtual coins and digital tokens. These virtual coins and digital tokens by themselves had value. For example, these digital tokens, some of them are called non-fungible tokens or NFTs, and they can represent different or unique items, even artwork. And this token is the kind of proof of ownership with these other assets. But more significantly for today's talk, crypto then brought to the fore the use of smart contracts. Put simply, smart contracts are basically contracts that are readable by a machine. They are in an algorithm form, and they can be executed by a machine in terms of buy, sell, trade deliverables, as in when something is to be bought or sold, on what terms. And this can be done by the machine without the need for anyone else interacting in the system. That means no institution, no bank involved in it. But as we will see, while this is good in theory, you still have an issue with interpretation of the contract when it comes to dispute, and similarly, when it comes to a dispute, how do you enforce your contractual claims for this kind of smart contracts? Regretfully, even though crypto was meant to take out the middleman, what has happened now is, unfortunately, it's become very much like the banking system itself. You have go-betweens, exchanges, intermediaries that do a lot of, give you a lot of services. And this then means that the system is getting more and more complicated. And the complexity can be seen from this case that I'm first going to start off with. It's very difficult to pronounce, quinine. It's a case that actually went all the way to our Court of Appeal. Our Court of Appeal in Singapore is the highest, is the highest court. It was very simple facts in the sense that you would now be very familiar with this kind of setup. You have a currency exchange platform which enables third parties to trade on this platform and so on. But not just this quinine did not just offer a platform. It also offered 3 different types of trading for people. You could do spot trading, margin trading, and futures trading with them. Margin trading means, as you would all know, basically quinine had a system where you could borrow funds either from it or others, and in exchange for this, you would also have some collateral kept with quinine on its systems. And in the event that the margin, meaning the transaction you wanted to transact, fell below a predetermined percentage, then quinine system would automatically make a margin call without, again, needing anybody involved in the system. So this platform by itself you can see this system or this crypto kind of environment led to many different types of contracts being involved in the trading platform. One is simply the trading platform between the traders, buyers and sellers, with the platform operator to regulate their relationship. Then in terms of margin trades for traders, for example, there will be a separate contract between them, borrower, and the lender. And finally, when the trade is executed, you will then have another contract being formed between the ultimate buyer and seller with, again, a go-between in the relationship between them. So this myriad of contracts has been described by our Court of Appeal as a spider's web of contracts. Having said that, let's now turn to this other topic. It's called interlocutory injunctions and cryptocurrency. So what does this mean? Let's say, your crypto wallets have been tampered with and the assets have been taken away. What can you do? You want to bring some form of a claim. Because this kind of asset is so fluid, somebody can move it from himself to another party very easily. So the law has this in place, what are known as interlocutory injunctions. These are basically binding orders or injunctions, directions, firm orders from the court telling the party that is accused of wrongdoing, you must not transfer this asset to anyone else, and you must hold it, pending the trial of this matter. So in the crypto world, in a crypto dispute, this form of interlocutory injunctions have turned out to be very useful. And just as an example, we look at this case of CLM versus CLN. For example, just on the contracts themselves, if you yourself are a crypto user, you'll note that a lot of these platforms or margin traders, their contracts allow them to change the terms at any point in time. And as I've highlighted in bold here, it is then your responsibility as a user to keep yourself updated with the current version of the agreement. On top of that, to double confirm the fact that they can make changes and that they have your permission to do that, they also always have these representations and warranties in the contracts that basically you, the user, agree that the company reserves the right to change and that it can be changed without providing notice to you of such change, and that you are responsible for reviewing the information in terms of the changes that might happen from time to time. So this is very good for the platform exchange themselves. This is very good for the margin traders because they have a lot of leeway to change the terms. But when it comes to a dispute, the problem then becomes which contract applies to whom at which point in time. For example, user X signed up today, so they would be relying on today's contract, whereas user Y signed up maybe 5 days ago and their dispute took place 3 days ago. So the version that is current then would then apply to them. And this gives rise to a lot of issues because that's the first port of call lawyers the first port of work that the lawyers have to undertake. What are the contracts in play? Which is the relevant one? Which version and to which party? And like the judges themselves said, this gives rise to a spider's web of contracts. But the facts are everyday facts. I mean, you had an individual, he had crypto assets stored in 2 digital wallets, accessible through his mobile phone, which the wallets themselves are secured with a password. And the wallets had recovery seeds. That means they had recovery seeds that could be used to recover the password if the mobile phone was lost. So what happened here is this person went on vacation. Mexico with several acquaintances. That's relevant because meaning that these were not close friends, they were just people that he had just met. And one night he went out, he needed cash, so he called back somebody in the group and asked that he retrieve cash from a safe in the room. But this safe also kept or contained the recovery seeds for his digital wallets. So unfortunately, what he found was after a while that his cryptocurrency had been withdrawn from his digital wallets, and somebody had walked away with his digital assets. So he started proceedings in Singapore to try and get, and as part of the proceedings, he wanted to get an injunction. The first thing unique about this case is, in the crypto world, you don't know who you're really dealing with sometimes. And in this case, he didn't even know exactly who had taken his assets. He just had a rough idea, maybe it could have been this group of friends. But because the crypto assets are so fluid, meaning person A takes it today, he can transfer it to person B almost instantaneously. What he had to do was start an action against persons unknown, basically unknown group of defendants. So nobody specifically mentioned in the case. And why is this relevant? Because basic common sense, when you start a lawsuit, you must be able to name your defendant or name the other party. But in this case, this was one of the issues he had. He wasn't exactly able to say who were the parties, and that information would only be available to him as the case progressed. And I'll explain how. So what happened here first was, could he bring a claim against persons unknown? And this was novel in Singapore. Could you really do this? And so what the Singapore courts did was they had recourse to the UK and Malaysian decisions in this area. These two jurisdictions were slightly ahead of us here, who said, yes, you can, and therefore his claim was allowed insofar it was as against persons unknown. But in terms of the injunction himself, now could that be granted? And usually to give the injunction, you need a proprietary right or some form of right. Is it you are bringing an injunction against money or a bank account or what? So then the first issue, very important issue the court had to look at was, what is the status of cryptocurrency? Do they give rise to property rights, for example? And in this case, what the court said was, look, I'll apply 3 or 4 criteria normally used for property issues. So because of this four criteria being satisfied, the court said, this does look like as if cryptocurrency seems to be able to fulfill some form of proprietary right, seems to fulfill the criteria of property, and therefore I can give the injunction. But I use the word seems because at this stage, when you're interlocutory stage, meaning the case hasn't been heard fully, it's just that you're asking for this interim order to seize or freeze the assets. The court said, at this stage, I think it is possibly a proprietary right, but I'm not going to commit myself totally to it. But I have enough to give the injunction. So you have this now strange kind of you're in this strange land that basically the answer is yes, cryptocurrency maybe gives you some proprietary rights. Not very satisfactory, but this was the state of the law as per this case. This recent case called Bybit, I'll just refer to it as Bybit, has come up. And Bybit concerned a company that operates a cryptocurrency exchange. It has a very unique way of remunerating its employees. It does it with a mixture of fiat money. Money is known as fiat currency in the legal world. So employees are paid through money or fiat and with crypto as well. And they had one employee, HR manager, who was responsible for processing payrolls. But what this person did was, she went to transfer quantities of cryptocurrencies meant for the employees to addresses secretly owned and controlled by her. Basically, there were addresses set up by her brother-in-law, whom she was directing at the back, as in terms of getting these assets, cryptocurrencies, transferred into his addresses, and then after that dealing with them by herself. And addresses are simply just digital folders where you can store and receive cryptocurrency. So Bybit claimed that, look, she also had transferred, apart from the cryptocurrencies, crypto assets, she has also transferred monies to herself. And for the purposes of claim, what they did was to bring a claim to say that all the crypto assets that you've taken away, wherever they are, you hold it on trust for me. And so one of the issues for the court was, look, for the purposes of a trust, there needs to be some proprietary right over the matter that you say is being held on trust for me. So that was one of the key issues. And the crypto assets here were US dollar US dollar tethers. That means they were stable coins linked to tether. And I'll come to the significance of that in a while. So the first thing the court here had to decide was, are these cryptocurrencies property capable of being held on trust? Are crypto assets a form of property? And if so, what type of property? So for example, you will all know landed property, that's fixed immovable property. But there are also other types of property. Money is a form of property. Cars, these are movable assets, but they are also a type of property. So the court here to decide what are crypto assets, what form of property are they? And the court did this in a few ways. One, it said, look, let's look at the companies themselves. Cryptocurrencies appear on the company's balance sheets, meaning they appear in the assets list and there's a value given to it. Secondly, even MAS has come up with papers saying that for digital tokens, it's possible to segregate, keep them separately. And that's usually how a trust is formed. Meaning, like if you tell a friend, I want to borrow, for example, your car, and against that, I give you $100, and this $100 you put it in a separate escrow account. That's the trust is over the $100, and that's where the property right comes in over that money in that trust account. So similarly, digital tokens, the same thing can be done. They can be segregated and put in special accounts. On top of that, the court itself, in terms of interlocutory injunctions, had given recognition in some form to cryptocurrency being a form of property. So for these reasons, the court said, look, I think the criteria is met, and cryptocurrency was, these are big words, but lawyers like big words. So what it said was basically you have an incorporeal right of property recognized by common law as a thing in action, and so enforceable in court. So what does this simply mean? What the judge was saying is your cryptocurrency rights, or why are they property rights? They are akin to, for example, IP rights, copyright or intellectual property rights. We have no issue seeing IP rights as a form of property rights. And so similarly, cryptocurrency also falls into that category. And therefore, to this judge, he said then the cryptocurrency meets the law's definition of property, specifically movable property. And he then also said that at the end of the day, this sentence here, the second one, you see, USDT is very special in that in its contract, there is a built-in that USDT can be redeemed by Tether for US dollars at a set price. So this by itself, showed that it's so close to money that some recognition had to be given to it as a property right. Okay, so this is done, meaning it is found to be a form of property, and then having satisfied himself that this was a form of property, then the judge went on to say, I give you that constructive trust that you're asking for over the crypto asset. That means wherever this lady has transferred the crypto asset, she holds it on trust for you, meaning she must give it back to you. More than that, he then said, an order that this lady has to pay back the sum of 647 being the value of crypto assets in wallets 3 and 4. So what he did was, there are crypto assets in wallets 3 and 4. There were 4 wallets in play here. So in terms of wallets 3 and 4, in case the assets cannot be found, cannot be returned as they are to the claimant, then I order that this lady pays the sum of 647 back to this claimant. How did he do that? He did that because, going back to it, there was in the contract a very clear right to redeem this US DT against US dollars. So the conversion mechanism was in the contract, and in this case, even evidence was presented as to how the conversion works. And so the court found itself comfortable enough to express the crypto asset here in the form of dollar value as well. And everything else, the second one here, the order is a simple one. Basically, this was already converted to money, some of the assets. So this was a straight repayment kind of order. For this sum of 117, you pay me back, pay the claimant back the money. So then this is what happened here. He gave a constructive trust, gave an order converting some of the crypto assets into dollars, and third one, ordered repayment of the monies ordered repayment of the monies, direct monies that have been taken by this dependent. And that's a Bybit. And because of Bybit, we can say today in Singapore, cryptocurrencies are capable of giving rise to proprietary rights, and people can take action to enforce their rights over their cryptocurrency. Okay, that's very good. Now, the next category is, can you wind up a company for a crypto transaction gone wrong? Can you do that? Because by law, if, for example, simple law is this, that if a company owes you more than $15,000, then you are empowered by the law to serve what is known as a statutory demand a statutory demand is basically a legal demand in a certain form that makes it very clear that if this demand is not satisfied within 3 weeks, I will then bring a winding up application in the courts against you. And if you don't pay against this demand, it is deemed that you are insolvent. So can you do this for crypto transaction, currency owed to you? That was the question that came up in this Three Arrows case. Three Arrows was incorporated in the DVI, and it was ordered to be liquidated because it lost a lot of traction after the collapse of Luna and stablecoin, and at its highest point in time, it had more than $10 billion in assets under management. So one company here, Allogran, it had a transaction with Three Arrows. Basically, Three Arrows breached that transaction, and because of that, Allogran demanded the payment of 53.5 million USDC, the cryptocurrency itself. Not strict money, but cryptocurrency. It demanded for payment of 53.5 USDC from 3AC. And so what it did was, under this section of the Insolvency, Restructuring and Dissolution Act, IRDA for short, there is this section here, 125A, the E, that says, look, a company can be wound up if it's unable to pay its debts. And under 125(2)A, a company is deemed to be unable to pay its debts if it does not satisfy a statutory demand within 3 weeks of the service of a statutory demand from the company. And so what Allogran did was they served the statutory demand for the sum of 53.5 million, and 3 weeks later, after it was not satisfied, they went to court to wind up the company. So the question before the court was, can I wind up Three Arrows on the basis of an unsatisfied debt denominated not in money but in cryptocurrency? The first question was for the court was analysis of whether Allogran was a creditor. So this first lib requirement to wind up was easily satisfied. Yes, Allogran was a creditor. But the problem is, can I wind them up? And this is the section that they relied on, 125(2)A. A creditor to whom the company is indebted in a sum exceeding 15,000, then due has served on the company by leaving at the registered office a written demand requiring the company to pay the sum so due, and the company has for 3 weeks after service of the demand neglected to pay or to secure or compound it to the reasonable satisfaction of the creditor, is deemed to be unable to pay its debts. And once you're deemed to be unable to pay your debts, you can be wound up. So the question was, this demand was not for a sum, not for a monetary sum, but was for cryptocurrency of 53.5 USDT. So could that satisfy this section? The court looked at it and basically said, look, in terms of society views money, crypto as money, but that is not enough for me. If you look at the section here, it uses the words indebtedness then due. In this case, the claim you have brought is based on USDC, cryptocurrency. This by itself is not enough to wind up the company for the purposes of this section. And he also then said, look, I know that this contract here has an easy way or has a right of conversion. The USDC value towards US dollar is spelled out in the contract. But the problem here is this section 125A, 125(2)A is a kind of a very, to give you a kind, you need a slam dunk case, meaning the point being that the court, upon hearing this application, does not need to spend time or does not need to go into detailed evidence to decide exactly how much is due. The debt that is claimed should be so obvious and clear that within a couple of minutes, the court can see that the claim is in doubt. So if here what the judge was saying is, I am not going to go into discussions as to how this can be converted to what value and hear evidence on that. That's not the proper way to do this. And because of that, for the purposes of 125(2)A, you cannot bring a claim, cannot bring an application to wind up a company based on a statutory demand for cryptocurrency alone. What you have to do is, I'm going backwards here, what you have to do is actually do what happened in Bybit. Basically, you have to put a proper case, get the court to decide they look at the evidence and decide what is the value of the cryptocurrency and make that judgment in terms of numbers, give you a value that you are now owed, for example, here, $600,000. And then based on that judgment, then you can bring a claim under 125A. 1252A. If not, then if you didn't do it this way, then you run the risk of your statutory demand failing and the winding up application not being allowed. So that was Allergrand, but there is one more case that I need to highlight to you today is Holdenot. I think you've heard about Holdenot. It's been in the papers for a long time. It's a platform whereby people deposit their digital tokens, they are paid interest, and Holdenot then uses these tokens, on-lends them to others, makes money out of that. And what happened here again is again linked to the similar issues of Terra and Luna, because the US Tether lost its ability to maintain the peg to the US dollar. Holdenot suffered and was not able to repay its debts. So on 8 August, it stopped withdrawals, stopped all trading, borrowing services on its platform. And it applied for what is known as judicial management. Now, judicial management is basically an interim process, meaning an insolvency practitioner comes in, independent party, to see whether he can do something to revive the company, get a better result for creditors, meaning sell parts of it and get better recovery for the creditors, rather than just putting the entire company into liquidation. Here, the interim judicial managers were appointed, investigated into the assets of Holdenot. They also considered the viability of certain offers that were made to buy the company, which were found not to be feasible. And so they then reported back to the court, and the court directed them to file an application to wind up Holdenot. And so that's what they did. But the problem here is, what is the basis of the winding up? Is it again just cryptocurrency? And you've seen Allergrand, so could it be done? But again, if you go back to the section 1251, again, I showed you this one earlier. Company is deemed to be unpayable, deemed to be unable to pay its debts. I showed you A, which is basically if you don't pay within 3 weeks of the statutory demand for money's worth. But there is this section 1252C. It is proved to the satisfaction of the court that the company is unable to pay its debts. And in determining whether the company is unable to pay its debts, the court must take into account the contingent and prospective liabilities of the company. So what does this mean? Basically, this means the court can take an entire view of the company's balance sheet, its assets, its liabilities, look at all of the accounts, and decide based on the evidence put before it whether the company can or cannot pay its debts. So here, this section is wider than the one we looked at. But of course, what happened here again is there was opposition to the application, and the directors here of Holdenot, they didn't want the company to be put in liquidation. So they got their lawyers to argue that, look, based on Allergrand, you need the debt here to be in money. Otherwise, you cannot wind up the company. But what the court did here was, again, it did what I'm saying applies. That basically, because you brought the application under 1252C, I can take a holistic view. Meaning 125C means based on all the evidence that the claimant produces on the company's financial position, then I can see whether it passes what is known as the cash flow insolvency test. That is, whether the company's current assets exceeds its current liabilities within a period of 12-month time frame. And for this reason here, the claim in Holdenot was allowed and the company was wound up. So, this one thing about this virtual webinars is I cannot see faces, but I'm sure all of you are puzzled by this, that how come one case can and the next one cannot. The thing is, this has to do with information. You see, the creditor in Allergrand, he was not privy to the entire financial records of the company. All he had was, you owe me 53.5 million USDT. So he only knew about his debt. And therefore, he could not bring this more holistic claim under 1252C. And if you file a winding up under 1252C, you are asserting that it's insolvent, it cannot pay its debts. You have to produce all of the company's records to do this, to show the court that it's really insolvent. The difference between Allergrand and Holdenot is this. In Holdenot, the judicial managers took charge of the company. They were appointed to try and see appointed to see by the court to investigate and see what could be done. And so they were privy to the entire company's records, and that's why they were able to bring this form of winding up application. And so then this judge then says, that's really the difference between 3 arrows, that in 3 arrows, because of the limited information, you have to go and get a judgment first in liquidated damages before you can use that section. But in this case, I have all the company's records before me, and I can determine that the company's assets are not enough to pay its debts within a 12-month time frame. And more importantly, the court also took note of future prospects and said no improvement to any increase in crypto prices would seem likely to bring Holdenut out of its difficulties, given that its net liabilities stood at about 92 million as of July 2023. Basically, what the judge is saying is, despite me allowing the winding up, I'm not saying I'm winding up because I recognize cryptocurrency as money. And in fact, today, in no jurisdiction in the world is cryptocurrency is cryptocurrency defined by the courts or by legislature, meaning through acts of parliament, as money. And so where are we today? Cryptocurrency is recognizable as a proprietary interest, meaning you can take action on it. It satisfied the test for property. You can get injunction. You can get orders for repayment. You can even wind up if you can go on the broader ground as to the company's balance sheet. You have that information with you. But if you want to do a statutory demand, you first have to take a full judgment to get it converted into money value, and then you can bring a statutory demand. So that's where we are at in terms of the legal position as to what is crypto. It is, what I can say is, it is not money, but given the evolution and the court's decisions in this area, in terms of enforcement, is almost as good as money. And so that brings me to the end of my short presentation. There's this other course that we're going to be running for IBF. This course takes a much deeper look at the cases I have presented and gives a lot more in-depth analysis on crypto in terms of even just to scroll forward as to cross-border issues cryptocurrencies raise and how you can restructure crypto companies. So that's something you can sign up for if you're interested. If not, I can stop here and you can turn to your questions.